estate planning, real property, surrogates court, they collide. Have a situation where there is an adult person came to me, child of deceased parents, mom and dad. One of the parents passed away. The second parent remarried, had been with that person for more than 30 years. Upon the passing of that second parent, what happens to the house? Well, the adult child that I spoke to, one of 3 siblings, this adult child indicated that my parent years ago said that this house, this property was going to be left for the 3 children. Apparently along the way, a will was a will was drafted, and now that the parent passed away, the will was produced. What governs? Well, that verbal declaration that this property will remain in our family, probably heartfelt at the time, meaningful, maybe a little sentimental. It's not going to carry the day. The ownership of a property governed by the deed. Can't have a verbal contract concerning real property. It's not permissible. Besides, so if the deed just had this parent's name, maybe the 2 parents and then 1 parent, well, what will govern that piece of real property is the deed. Yes, the deed governs it, but what will control it upon the death of that person is the estate plan. So if that's a last will and testament, that governs. If it's a trust, if the property had been placed in a trust, then the trust governs. So it doesn't matter what people say. You need it in writing. You need it in writing, and you need it in writing for your benefit. So the thing is, that parent may have wanted to give the property to the second spouse. Together more than 30 years. At the very least, probably wanted that person to be able to live there the remainder of their days. But perhaps that parent also wanted to protect the children from the first marriage. You can't tell what is in the mind of a person. What did they say 20 years ago? What did they say 11 years ago? What happened last year? The document is called a last will and testament. The last one controls.